Good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series and our Meet the Paralegal Bencher Candidates special. Once again, the disclaimer, all the views and opinions are of the candidates themselves, not me, Charles College, anywhere else I'm with. And really happy, learning a lot from all the different candidates we've had on this week. And today I'm really happy to talk to Josh McDougall here. Josh, maybe you can start, tell us a little bit about yourself. And
Sure.
Thanks for joining.
Yeah, thank you for having me, JP. I appreciate it. So my name's Josh. I am the managing partner and founding partner of a law firm in St. Catharines, Ontario. We have a couple of offices throughout Southern Ontario. I've been a licensee of the Law Society going on 5 years now, general practitioner. I do a number of different things, and I'm really looking to try and make a difference. I ran in the last bencher election. I met some great people, and not that it's anybody's fault, but I think some serious things went off the rails during this past term, and there's certainly some room for improvement. Of course, there always is, but that's why I'm here.
Yeah, so maybe you could tell us a bit about, you had that experience the last time. Why run again, and what it's like, I guess, going for it the second time now?
Yeah, absolutely. So the last time, I'll be completely candid with you, I knew I wasn't going to get elected. The last time was merely for experience. I got to meet some of my colleagues and fellow licensees. I got, a little bit of a better understanding of what all of us deal with as paralegals, not just, at the time, my limited understanding of things. So it was really it was a key learning experience. I had been licensed for 4 months or 5 months at the time. So to, kind of jump into that pool of people who have been doing this for some of our colleagues have been doing this for 30, 40 years pre-regulation. So the opportunity to meet them all was a massive learning experience, and I got exactly what I wanted out of it. And a little bit of name recognition within the industry. Certainly not a ton, but a little bit. And that's all I needed. This time, the core issues that I thought about when I was going to run last time are still issues today. And although some of our colleagues that ended up getting elected really wanted to make sure that things like family law got dealt with, or, the promises that immigration was really going to be considered, or the competency of future licensees, the education component, those were things that were talked about, and it was mentioned and semi-promised that it was going to get taken care of, and it still hasn't. So I was toying with the idea of not running. I've been asked by a few lawyer associates of mine, to run. Grace Pang, who is an ex-Crown in Niagara, she asked me to run pretty relentlessly, and couple all the long-standing, non-checked off issues on the list. We're dealing with a lot of administrative overreach, a lot of things on the Law Society end that I know a lot of us are frustrated with, and that's why I'm running. I could go into it for hours. I don't think either of us want to do that, but that's the Coles Notes.
Okay, so let's then look at the platform and maybe some of the most important issues that you see on the table here for this election, and maybe you can tell us a little bit more about it. And you mentioned overreach there and yes, scope and some of the stuff that you were looking at 4 years ago that you think are still on the table. So let's go through some of the main issues.
Yeah, so I've kind of separated my main issues into two different components, right? So there are issues that affect just paralegals, and those issues are, just if I were to give them headings, it's scope, competency, which deals with the education component, and then there are issues that affect all of us: lawyers, the public, paralegals, even law clerks. It affects to some extent or another, and those are issues like, family law. This new license that they've provided for us, rather than just extending our original scope. There's the immigration component that straddles, but then the main issue that kind of falls under the everybody heading is the overreach component. So as far as our scope is concerned, I think we can all kind of agree, and I'm not sure how much you've looked on some of the posts that have been going on. I've only started getting involved with that. Immigration has been an issue for years. I know Tony Caruso has talked about it a lot, and I mean, I think it's fair to say he's in that category. He's really been our champion, or at least the forerunner, trying to plant the flag on it. But immigration is something that we've all kind of looked at and said, well, why aren't we doing it? Why can't we do it? So the law says we can. Everybody else says we can. The only barrier, at least from what I can see, unless somebody wants to point me in a different direction, is just what our scope allows. So bylaw 4. Now, I had a conversation today with somebody, and maybe that'll come up later, but the Coles notes to that where bylaw 4 really don't even need to change. It's just how it's interpreted and applied. And I think all of us are really anxious at the ability to not just be pigeonholed. And I mean, that carries into the family law component. There are some of us that pre-regulation dealt with family law. So when we were regulated, and I mean, I know I'm kind of talking out of turn, but I've heard about it from a lot of people. I've only been licensed for 5 years, but I know people very well who I now consider close friends who have been, in this for over 20. So the family law component was something a lot of pre-regulation paralegals dealt with. Things like divorces and easy applications. That was stuff that some of us who are still practicing today and providing legal service, they did already. And now, I mean, the reason it's still on my list of core things I want to look at is because it was promised to us, 4 years ago when I ran the last time that, we're working on it. And this is the report we're working off of. And the report says, we're going to expand the paralegal scope. It was in the best interest of the administration of justice. It was best interest of, providing legal service and access to justice to the public. And yet, instead of that, we get some kind of hybrid offshoot that isn't even connected to paralegals. I mean, it had absolutely nothing to do. The end result had nothing to do with expanding our scope. It had everything to do with providing a new cash grab, for lack of better words. I mean, I'm trying to be candid with you. I hope that's okay. No one's going to use it against me later. But, well, they might. The reality is that this new license allows for paralegals, whether they had the competency prior to regulation or not, law clerks, and any other individual who's worked in a legal capacity. And I say that because we can now make the distinction between licensed M1 law clerks and just people who have been doing it for 30 years. And they can go do another 6 months of school, and then they can get a stamp to pay dues, to pay for insurance, and their scope is, I think I read the full report, and it's 4 things. That's not a fix. That's not a solution. That's not a solution to anybody. Certainly not the public. It's definitely not the paralegals. And I challenge anybody to tell me different. It's a half measure at best, and it certainly does not live up to the promise that we got 4 years ago. And it needs to be recalled.
Okay, so let's say, Josh, if you get elected, and the second part to it will be, obviously working within all the other benchers, lawyer, lay benchers, the other paralegal benchers. But let's say you had the power, whatever, to make the family law scope as you could craft it. What would you say in terms of what paralegals can do? You mentioned education, competencies, and things like that. So what would it look like compared to what is sort of proposed now on the table?
I am a big supporter of, although there needs to be some expansions to our scope, a lot of the area we have contains a lot of knowledge if you look into it. And I say that because I think the proposed scope for a paralegal to practice family law should fall within the knowledge base we should have now as practitioners. So things like real estate, that falls outside of our scope. Yeah, we can deal with stuff at the tribunal level or the land tribunal, but realistically, if we're dealing with constructive trusts or real estate issues gone bad, that is a lawyer's area of scope. So our family law stuff shouldn't have anything to do with real estate. So then we're dealing with divorces. Then we're dealing with simple custody matters, nothing where there's assets or property. The other, and I know that I had spoken with Robert Bird about this, and this was years ago. And what I had said then and what I still stand for now is it is absolutely, as long as the practitioner is properly trained and competent, we should be allowed to deal with CAS matters. And the reason I say that is we have scope within the summary conviction court. CAS apprehensions start at that level, and they actually function in the family court under the Ontario court heading. There is a lot of overlay between how an apprehension starts and carries out, because it's through an agency, and it's not mom and dad fighting over the kids. So CAS, I mean, that's stuff that we can deal with all day. Yes, there's a lot more on the line, but administratively, it's the same steps. It's the same stuff we learn about, and we're still dealing with an agency. So that absolutely should be on the list. And the reason I support that wholeheartedly is it also lays into Legal Aid Ontario. Legal Aid, and I can tell you from personal experience, because I'm the managing partner of a law firm, so we have lawyers. We accept certificates from CAS that are 45 hours, so that's roughly $5,000. No other family law certificate gets that kind of money. Legal Aid is constantly looking for different ways on how to save funds and make them go farther. Yet no one, despite it being the Law Society Association that deals with the funding to legal aid, no one has dealt with the sheer fact that by installing and impaneling paralegals, we could deal with a ton of stuff at a fraction, or call it 50 cents on the dollar, like a lawyer does. It would save public money. It would give us all expanded business. And it supports the proposition that we should be dealing with family law stuff that is dealt with by way of certificate. And CAS matters is a massive thing on that list.
Okay, so then let's say then that's the area, give or take a few other things.
Sure.
But now what would be the transition then? Is it, they propose obviously, get another license and then, or you finish education, then you can write a test, I believe, there, get this other license, and then away you go. Do you propose something different? I mean, I know I've talked to Jeff and Matt, the last couple of days, and they essentially say, well, we're already licensed. Perhaps it's having some professional development. Perhaps it's maybe just taking those same core competencies that you have, right, in terms of representation. Whether it's if you want to move from small claims, like you're saying, a general practitioner, suddenly, in St. Catharines, there's an influx of WSIB work, and you're like, I haven't done this before, but I want to start doing it. There's nothing stopping you from doing that, right? But
correct.
Is that sort of same thing now? If you have this scope in family law, hey, it's no different than me switching areas, or does there need to be either education or competencies, or is it something on the disciplinary side? What, if anything, needs to be done to address that kind of counterpoint of, hey, there's going to be people that are not very competent to handle some of this family matters. They didn't go to school, they didn't get tested on it. Is it in the public interest if they're bungling up some of these CAS or whatever family matters?
That's an awesome question. I think that it shouldn't be another license, not for us. I'm not saying that the use and production of a new license, especially when it deals with law clerks being able to deal with some stuff in a more expeditious fashion, I think that's awesome. But to couple us in with that is just redundant. It is exactly like you pointed out. I mean, so that's really the one area I don't touch is WSIB. But if I wanted to, we're taught the main abilities to decipher, read, and interpret legalese. That's just the reality of it. That's what our education does. Yeah, we learn how to fill out some forms, but realistically, that's what we're learning. That's what our course is supposed to do. So all we have to then do is just read the Children Law Reform Act or the CAS. I always forget the acronym for it, but the act that deals with CAS matters. And that, by the way, is within a tribunal. So yeah, I think it's discipline coupled with some professional development. And that's it. I mean, you should be able to say, yeah, I've gone through this course. I know how to interpret my core competencies in this manner. And that's it. And to be fair, like you've said, that's more than what we have to do if we make the switch between, well, I do landlord and tenant board now, and I want to take my first small claims case. It's the same stuff. I mean, we can represent individuals when it comes to going after CAS when they've done something wrong, because that's part of the social benefits tribunal. But yet we can't represent the client with the same information, the same knowledge, the same understanding when it deals with actually battling them when stuff is important. So I think it is an easy course between what we know and what we need to know in order to practice and to assist the general public in that way.
All right, so let's switch to the other immigration there, right? I mean, not necessarily agreed with Jeff and Matt, because I saw it as, there's two issues here. One is, legally, the courts are going to make a decision. They're going to do, Section 91, 92 analysis, doctrine of paramountcy, and so forth of if ultra virus. But I mean, the secondary issue is, regardless of what the courts could say, I mean, the Law Society could just open it up, right? I mean, then it's just a question of, should you be able to do it? Is it in the public interest for you to be able to do it? Now, I don't know. I mean, like I said, Jeff and Matt sort of saw them part and parcel together that, well, hey, it's the rule of law. The Law Society should obviously follow the rule of law. So I don't know in terms of, well, one, there's going to be a court decision, but two, regardless, the Law Society doesn't need to even wait on that. And they can say, you know what, let's just allow paralegals to practice, whether interpreting bylaw 4, let's make it clear. This includes completing application forms. And even in other tribunals where, it may not be clear, like if you can provide a opinion on a contract or something, if it's not going to small claims, make it pretty clear because that's within their ambit, I would think, right? So what are your thoughts there with respect to that and immigration generally?
Yeah, so I think it is certainly so I'll start by saying it's certainly within the public interest for us to be handling matters from start to finish with immigration. And I don't think it could ever be stated to the contrary, that it's not in the public interest. The Law Society, in my opinion, in my view, they absolutely could open it up right now. Why they don't, or why it's not an issue or a hot topic, I don't know. I can't speak to that. Right. I think somebody did the math and it's only like 40% of convocation is actually on video. The rest of it is all backroom talks, and they're absolutely right. So why it's not getting brought up, why it's not being dealt with, why it's all of us talking outside of convocation about it and nothing's really happening, couldn't tell you. In my view, the Law Society could. Bylaw 4 could be explicit. However, Bylaw 4, as it comes to paralegal stuff, is very rarely explicit. It's a very general set of terms, and it kind of leaves it up to us to interpret, which is difficult. And then they, kind of make it incumbent upon us to either know definitively or call practice management. I think the courts, they could go either way. And you said it perfectly. They have to make the analysis. My question is, doesn't the Law Society ultimately have the ability to, at their discretion, impose or retract whatever they want from any of us? Right. So the ability to make our bylaws is through the Law Society Act, and they did through convocation. I'm going to struggle with whether or not the court can actually force the Law Society to do anything, whether they can force our way in, because they withhold, or they hold rather, the ability to do what they want, as long as it happens through convocation. We have our own internal parliament. I don't know that an outside court can actually rule, and I say outside knowing it's the Superior Court, but realistically, they gave us the tools to kind of do it all on our own. I kind of think of it like Lord of the Flies a little bit, but we have the ability to govern ourselves. I don't agree with how it's been done to date. I think the court will rule in our favor, but I think the Law Society will have a very good argument that they get to control that. It's not for anybody else to determine. And unless they want to take away the provision of the Law Society Act that allows convocation to make our bylaws, that's going to be a tough one. Yeah, I mean, and it also brings up a very good point that bylaw 4 kind of needs to be overhauled completely. The reasoning is, just like I said, it's far too vague. I mean, it doesn't, and I appreciate that prior to us, nobody had a scope. They could, you're a lawyer, you do whatever you want. So to bring us into the mix called in a whole bunch of questions. And a lot of what makes law is trial and error. I mean, that's why we have, amendments to statutes over time that needs to be developed. Well, bylaw 4 is not really any different. We've been in this now for 15 years, or 16 years rather. We've been regulated and governed, and they haven't really done anything. They certainly haven't expanded it, and they need to give that to us clearly. I think I answered your question and all that.
Yeah, I mean, I think certainly, like I said, that the Law Society has the power, and the benchers have the power, right, to affect that change, irrespective of, and possibly, you get a Superior Court decision, someone may appeal it, it's going to be still through the pipeline, until it goes to potentially the Supreme Court, that you're going to have a definitive ruling there that it could be a lot faster, within the Law Society framework. And I guess that in both of those points then ultimately come back to, there's 5 paralegal benchers, there's 8 benchers, public benchers, and then there's 40 lawyer benchers. So collectively, you need to get 27 votes, right, for anything to go through.
Yeah.
Now we're in kind of an interesting dynamic, and forgive me, I mean, I don't know, maybe 12, 16 years ago, maybe they had similar kinds of issues where you had, slates of maybe real estate lawyers versus family lawyers or something. But we have 2 very distinct slates or coalitions running on the lawyer side, and some include paralegal benchers as well, and the good governance, and then full stop, and I think they may be endorsing some paralegal candidates as well. But in the end, we could have all of one side, all of the other side, half and half. And in that case, the 5 paralegal benchers, if they're not associated, as well as the public benchers, have, they can wield the power, kind of like, like Jagmeet Singh right now, right? That can prop up the government, right? So in that sense, is that kind of what you can see better able to get some of these things through? Because it's going to be a difficult sell if it's just the 5 paralegal benchers and maybe some of the public benchers. That's still going to get you maybe 13, and you got to still convince 15 lawyers or so that, hey, this is good for the public interest.
Yeah, I think regardless of the slate that the lawyers are running on, I think it all boils down on the immigration topic. That, I mean, we're all people, regardless of your license or your background. It's cold hard facts. I I do agree with you that it creates for a little bit of an issue if the five, paralegals that really by themselves can't get anything done. We need assistance, either all from the layman benchers or a little bit of the lawyers. But outside of the partisanship, we're all just trying to deal with the same stuff. And the issue on immigration alone, I mean, that's not one that I really think falls under one slate or another. I'm sure you meant it more in a general kind of sense, not just the issues of today. But it does create an issue when we are seen to be on the other side of things. I mean, it's sad, and I've discussed it with friends in the past and colleagues, and it kind of is like the paralegals are the kids that just weren't invited to the party. Or maybe it's just me, but that's how it kind of feels, right? 40 of them, 8 laymen, but we don't even get 8. We get 5, and we're representing a class of licensees who have just as much right to be there as the lawyers by now. And it does feel like we're just not part of it. And that's a problem. And that's a problem because of a whole bunch of different things. But the main one is that a lot of lawyers, in my experience, don't see us as equals. And that does come down to a personality thing. And I think a big consideration in this election does need to be the acumen and the abilities of the people that we're representing. I mean, there's 4 spots up this year. It's not like last time where the tenured benchers who had been there for 2 terms already would be able to walk the new people through. Robert Byrd could have introduced me to everybody he knew and then passed the baton when he left. And then, at least I'd have the same connections, not necessarily the same views, but same connections. But this time we're being fed to the wolves. So we really need to be selective with who we're choosing to represent us. I mean, you need people who can work well on the fly. They can, work with lawyers. They can command their respect, and they can battle intellectually on par with them. And I think, given that kind of difference, that's important. And again, I know I talk a lot. I think we all do. It's part of our profession, right? But I hope I answered your question.
So yeah, so I mean, I guess I've heard over the the last few days, and I'm sure again when I talk to the rest of the candidates, things about, well, hey, do we need to increase the amount of benchers that we have? I mean, what's the process of doing sort of electoral reform? Is it kind of looking at, well, maybe 15 years ago when this is starting, there's a huge discrepancy of lawyers to paralegals in year one, right? Of, I don't know, like 50,000 to like 500. So maybe that was part of the, the thought process then. But I mean, look at the licensees, year over year now. And if we're seeing, that gap is certainly not 8-1 anymore, that maybe that's the sort of impetus to say, okay, what can we do here to have a stronger voice collectively? And again, even though lay bencher, paralegal bencher, lawyer bencher, you're supposed to be in the public interest, right? And I guess there's always that sort of inherent tension, right? That, hey, lawyers elected me or paralegals elected me, so I still have to represent their interests, right? And when we're talking about scope, but ultimately it's the public interest, lawyer or paralegal or layperson. If these things make sense, then that's sort of your mandate, right? So do you think there's a number, of where you'd like to see it go, or do you think it's more about bridging those connections with lawyers to say, hey, what, we can pass this, even if there was one paralegal bencher and 50 lawyer benchers, if they understand, it's in the public interest?
I worked out the numbers last time, and I worked out the numbers only so I could just be a pain in the ass. But it worked out to be the 40 lawyer benchers represented, I think it was like 8% of the total lawyers. And so we were at, again, I worked it out before, I don't remember it exactly now, but it was like 6%. So my suggestion was, well, why don't we make this the same percentage at the very least? Like 40-5, it seems like David or Goliath. The reality is, if we look at it as percentages, we're not that far off, but give us even say there is more lawyers and so therefore more interests to keep up with than there are paralegals. I get that. That's fine. I do think that public interest is extremely important. And so we need to even the playing field so that everybody who represents the public has an even say. I mean, you can't really take in all of what is in the best interest of the public if you're not giving a percentage of the law society that is representing the public a fair say at the table. And if they're not going to give us on par 40-40 so that we can make our own votes without them, as long as we got a couple laymen's, we're never going to be on the same footing as them, as sad as it is to say, but give us the same percentage, give us the same kind of consideration. But you said it right. This is all about public interest. It is not in the public interest for us to have this minuscule, almost meaningless, because you said it perfectly, they could almost create their own bylaws themselves. They can do their own voting. There's 40 of them. We only need 26 to pass. They don't need us. If we object to it, all of us, it creates for this almost dissension that can't be fought. We have, so it's certainly within the public interest for us to get more. How it changes or when it changes, I mean, that's a bunch of steps, and it's not going to happen overnight, and it's not going to happen within the next 4 years. I would like to see us get one new bencher, one new slot. I think given the rising population of paralegals in Ontario, there needs to be some further voices at the table, and it just starts with one. I mean, they don't need to give us another 5. We don't need another 15. Just give us one and see where that goes.
Yeah, I mean, because even just having like representation of benchers inside Toronto and outside Toronto, as the lawyers have, you just have 5. They could all be from Toronto, and then if you're out east or if you're up north or in Niagara Falls or St. Catharines, you're like, well, hey, I can't really connect with the opinions there. They don't see it the same way as what we have regionally. Like that's why part of the reason the lawyers have that.
Yeah, no, I agree. And I mean, the other really important thing to consider is they make this difference between the inside Toronto and the outside Toronto because the needs of the public within Toronto, in the heart of the city, drastically different than out in the suburbs. It just is, right? I mean, so the needs of the public in Niagara, where me and Tony are from, I mean, it's way different than what somebody who lives on Yonge is going to need. And so we need adequate representation across the board, regardless of jurisdiction. And we need more voices, because if we do get just people that are voted in Toronto, then the rest of us are kind of screwed.
Yeah, so I guess maybe we could look at, I think the other point you brought up at the top of the hour here was about overreach, right? You said it's more general. The Law Society should be doing certain things, shouldn't be doing certain things, right? So maybe you want to expand on what areas you think the Law Society may be overreaching in. We've talked about scope, so I mean, beyond that, what else can they sort of keep their hands out of the cookie jar, so to speak? And I don't know if there's any other points within that or something else that you'd also want to address as well from your platform.
Sure. Yeah, I appreciate that. The big issue with overreach, I mean, it's not just one problem, right? They all kind of go hand in hand, and that's what makes an informed platform, right? When it touches on multiple issues, not just one. But the issue of overreach in my kind of mindset is the Law Society is supposed to be there for the public to ensure that we're not doing something that is not within their interest, and that we're competent and providing good service. That really is what the Law Society is there for. So without giving names or specifics, I can tell you that I know of a complaint, and this is just an example, and I'll keep it short and sweet, although I like talking. The complaint stemmed from a representative losing their temper on a client. I guess it was like a death by 1,000 cuts kind of scenario. It was just, I didn't say anything wrong, but told the client where to go and how to get there. Well, I guess the client recorded the phone call and sent it into the Law Society. So the Law Society made a big thing of it. Conduct unbecoming, take a course is what it is. Problem solved. Well, I guess the Law Society wasn't happy enough with that outcome, and they referred, it was the retainer agreement of the paralegal to another division of the Law Society. And I guess that one paragraph that dealt with trust transfers gave them rise to question whether or not somehow money was being transferred without billing it first. And so now that practitioner is under an audit since October based off of a conduct unbecoming complaint. And it's that kind of stuff. One, it's not, you can't tell me that's in the public interest when a complaint that had nothing to do with trust money gets misconstrued and miscontorted into, well, where's the trust money going? It's a reasonable question. I mean, we all have to deal with our regular audits, but a out of nowhere, unrelated kind of guise of this complaint, it's not in the public interest for the resources of the Law Society to be directed in that way. It's not in the public interest for that paralegal to now have his focus split between his clients and his obligation to the Law Society. And so it kind of goes into the next area of consideration, which is the bloat, right? So this overspending. Well, shouldn't that auditor's time be spent on, I hate to bring it up, but we always see these massive headlines, especially in Toronto papers, where lawyers may or may not have done something unbecoming to a client or withheld money from trust. Why aren't they looking into that? Wouldn't that be better? Where's all the money that is being spent going? Because you're not going to tell me that the one guy who's auditing paralegal who did nothing that was connected, and I'm not saying that guy did anything wrong, but I am saying that the complaints don't match up. So why the misuse of assets? I mean, if I were, so I run businesses, that's what I do. Well, why would I want to put an employee on something that was irrelevant unless I had enough money laying around just for fun to pay her to do it? If that's what the Law Society is saying, that the ropes need to be pulled in. The money needs to be funneled in useful ways towards things that matter to all of us, public and practitioner alike. I think I answered your question. I think there was a part 2 in there and I missed it.
I guess in terms of, so where should then the focus of the Law Society in terms of, I mean, part of it could also be, I was reading today that, the licensing fees for lawyers in some US states are like a tenth of what we pay. I think like $250 in some places. Is that, we scale back on these things and we take back, in terms of fees that we charge to our licensees, lawyers and paralegals alike? Or is it, we don't reach in these areas, but we're focused on other areas and do that more efficiently? What sort of, where should the Law Society be doing?
Well, there's no wrong answer to what you just said, right? Do I go left or right? Yes. It's either or is fine, but do something. I mean, they could either, if they could create in-house, I mean, if we're spitballing, they could in-house create the program for paralegals to transition into family law if they really wanted to with the same funds. Or they could stop gouging us and draw back on the fees. I mean, I appreciate that I've been semi-successful and I'm humbled about that, but I know that I have colleagues that aren't in the same boat. And so the amount that they spend on professional fees or the referral service from the Law Society, I mean, that hurts the bottom line of somebody who is, you know, a small business owner, because that's what a sole practitioner is. They're a small business owner. There needs to be considerations of that. And I don't know what those considerations look like right now, but there do need to be considerations for it.
Now, with the Law Society, in terms of what we're just talking about, what in terms of the competencies, right? Like, the Law Society, in terms of paralegal education, for example, there was a report last week at Convocation. They're more hands-on there than with law schools, for example, because it's not in their jurisdiction there. But is that something that again the Law Society needs to be overseeing, or is that something that, hey, we check in on the schools, make sure obviously we accredit them and the programs, and at the end of the day, we have a licensing exam. If it doesn't matter where you went, what you did, if you can't pass this exam, that's the barometer of if you can cut it and be welcome. One of the things, obviously, you have to be of good character and so forth. But is that something, again, where they can sort of scale back, or is it something different? Because I know you also brought up competencies at the start. So I don't know what maybe in terms of that you see needing to be done.
Thank you for that. That's a good one as well. When I ran last time, I was really concerned with the education component and how we treat the internship between graduating from paralegal and writing our exam. And the reason this is of concern to me is I've watched the lawyers in my practice, even from schooling into articling into practicing. And it's like night and day. So they being the lawyers, 10 months of articling versus our 120 hours. We're supposed to, whether people acknowledge it or not, we have 600 tribunals. We can practice in all tribunals. There's a lot of information for us to know there. But we get 120 hours where if you're lucky enough to get in with the Crown Attorney's office, like a lot of my classmates did, they were shuffling papers around, so zero court experience. If you get in with a law office, same thing, you're answering phones. I was billing out legal aid certificates for a lawyer. And the comments that came from the last election run was, why are we going to pay or appreciate our potential future competition? And that was the concern, because they weren't giving the students any real work, right? So whereas an articling student it has the exact same scope as us. They get to go out, they get to pick up files if they want to under the purview of the lawyer, but they get some meaningful information that dictates and puts them on a trajectory of how they're going to practice law. We get to learn how to file papers. So, I mean, the competency, it's really no one's fault as far as the student or the paralegal, but there needs to be a change in our internship. I am probably the worst student I could think of. I mean, I went. Did I hear you right? You went to Trias?
Yeah, I teach at Trias. Yeah.
Yeah. Okay. Oh, okay. So I went to Trias. So I was famous for things were due on Friday. I did them Friday morning, and I was zonked out the rest of the week. I barely paid attention. I learned everything in my internship. I had it started off horrible by me billing out legal aid certificates, but the lawyer had me going to court every day. So every day I was in criminal court. Every day I dealt with bail. Every day I dealt with set dates. Every day I dealt with clients. I'm the only student from my class that I know that had that kind of internship. And then my internship turned into a job until I got licensed. Our colleagues aren't getting that. They're getting learned how to fetch coffee, how to look at a file, and how to put it away. How are we supposed to be on par with what a lawyer gets? I mean, we're supposed to be able to apply our knowledge for our trade the same way that a lawyer takes school through articling and practices. That's our internship, or our articling is our internship. Drastically different, but we're expecting the same results. So our competency really needs to be addressed by way of how we deal with internships. Now, I know there was talk about it last time around where, no one wanted more internship hours and how would we sell it? And it's in the public interest that our future paralegals know what they're doing. Now, it's not just about landlord, tenant board, small claims, and provincial offenses. It's just not. I mean, some of my biggest cases have been in the Ontario Land Tribunal. They don't even tell you that one's real. Like that's the reality. It's not, I didn't see anything about the Committee of Adjustments on the LSO exam. And there is no necessary or real coalition all the time between how good a student is and how good they're going to be at their career. Like I said, crappy student. I'm surprised I passed the LSO exam. Not because I don't know my stuff, but because I suck at tests. That doesn't mean I suck at my job. I'm okay at it, but the alternative is also true. Just because somebody studies the material real well, those 1,000 pages that, by the way, are open book and we can look at the answer, nothing says that that person's going to go out and do a good job for themselves or for the public. So the learning hands-on portion of what we do, our articling, that's got to be worked on.
Yes, because I believe now, I mean, I don't know how soon it will, there'll probably be some kind of directive to the colleges that now it's going to be 240 hours. But as you're telling me, well, it's like 240 times 0 is the same as 120 times 0. If, we're not making sure both, from the college level, but, with the law society that, these internships are getting meaningful. And even beyond sort of that piece, right? Is there more mentorship that can be done, either right after you're licensed or prior to, where you're getting more hands-on work? Because again, as much as you may have gotten education 5 years in your case, 10 years, 15 years, whatever, it's continuously sort of learning and working and getting that experience that's going to ultimately be the barometer of how well you can practice.
Yeah, I agree. And you've got me at a little bit of a disadvantage. I haven't read the convocation report yet, but I'm happy to hear that they've expanded the hours. But you're absolutely right. So what happens in articling is they have an articling supervisor. And we kind of have the same thing, except where an articling supervisor is directly responsible and has to take notes on what the articling student is doing or has done, we just sign a piece of paper at the end that says they did all the hours. And it's a little bit different of a threshold. And I don't think anyone can say it's not, but we're expected to do the same job. I mean, if I'm at landlord and tenant board and a lawyer is at landlord and tenant board, my client shouldn't see a difference. So why is my training less? Who cares if it's less hours, but it's less high impact. And I know it's a little controversial, and I'm taking that in only because of what I remember from the last election, but I mean, there was serious concerns about the potential of training our competition. And I know I just said that prior, and it's really just resonating with me again, because I can't believe how nonsensical that sounds. One paralegal out of the 12 or 14,000 of us isn't even on the radar. If it's just one, we need all of us to be okay. We need all of us to be at a certain level. There's going to be some of us that are better in certain areas than others, but we all need to hit the bar. And the bar isn't a reflection of how well you do on the test that they don't give us grades for. It's the LSO exam, but it's like the issue at hand is how we treat one another and how we expect our student paralegals to blossom and represent paralegals moving forward, if that makes sense. We're not taking care of our next generation at all.
All right, now Josh, just about 5 minutes left here, so I
Yep.
wanted to give you one last chance. Maybe tell us a little bit, if anything that you haven't got a chance to highlight that you're looking for in your platform, and any other issues we may not have touched on in the interest of time. There, just maybe summarize, what else paralegals that are going out to vote should be taking into account.
Sure, thank you. I really want to thank you for having me on the show. I'll wrap that into my 4 minutes. But I really think it's important for all of the paralegals that are going out to vote, who vote. Don't just remember the day, write it down and think about it and then say, I'm too busy. Vote. It's important. It impacts the public. It impacts the next 4 years of our careers. I said it previously, I'll say it again. I think it's important that the acumen of each individual candidate is kind of thought about. How are they going to react with lawyers? How are they going to react on the fly? How are they going to react going into a whole world they've never seen before and representing all of our interests? I think we brought it up well. Competency is a big one. Overreach and administrative issues at the LSO level. Our scope of practice needs to be expanded on. Big one for legal aid funding. Just trying to think if there's anything else. Those are the big ones, really, to me. Yeah.
And then I guess the follow-up would be, why should Josh get your vote for any paralegal listening?
Well, the goal is to find somebody who can work well with the lawyers and bring the 40 down to the views of the 5. I do that every day. I'm the managing partner of lawyers. I don't think anybody else is doing that. I know that's cocky, but I had to say it at least once just so I could hear it back. There has to be some cockiness in an election, right? You're smiling.
All right, so perfect. So Josh, last question here there for the students, who can't vote and been listening and, getting involved here, and, who maybe their future benchers there. Any final words of wisdom for them? And thanks so much again for joining us today.
All the students shouldn't be. So I'm talking to myself, 6 years ago when I'm talking to the students. Fight for everything you can, and don't be afraid to try and practice something just because you have never taken a case on it before. We get taught the keys on how to interpret things, and it only takes one case for you to have experience in that area. Do whatever you can and succeed. And I wish everybody the best of luck.
All the best to you as well, Josh. And thanks for everyone for tuning in. And tomorrow we're back at 5 to wrap up our first week here with Sean joining us. So take care, everyone.
Bye now. Thanks.
Thanks, Josh. Thanks, JP. You guys have a great night.